For that, let me express my gratitude to all of them. I welcome you all, especially my brother judges from Patna High Court and sister, and few of my friends who have been with me through the thick and things. And the other thing that I want to tell you is for the consumption of the bar. You would be absolutely free to voice your grievances before me. But of course, within the limited parameters, I would be there for you, and I'm not going to ever stoke with the traditions of this High Court. See, every High Court has its own ethos, has its own system. That shall not be interfered with. And if I wish to bring anything new in the High Court, it will be with the consensus, something new, which I found to be very good. And if it suits you all, we will try and introduce, but not without taking all of you on board. So let's begin today. Yes.
Adjournment request, if any, from item number 1 to 4. From item number 5 to 14.
May it please your lordships.
Yes,
Lordship, an adjournment request was circulated with regards to item number 6, your lordship.
that's right.
Lordship, my senior is not available right now.
What time do you want?
Lordship, the day after tomorrow would be convenient because
As prayed for. I will notify on so and so date. Day after tomorrow.
22,
much of late.
23, 7. From item number 15 to 23.
May it please the lordship, my lord, I beg to mention item number 17, my lord. I am appearing for the respondent, my lord,
Yes.
and he is appearing for the appellant side, my lord. I pray for adjournment of the matter for a period of 4 weeks, my lord.
4 weeks is a long time, isn't it?
My lord, actually, what happened, my lord, in this matter, the government has to pay some remuneration to the appellant.
That's right. Are you agreeable?
Yes, ma'am, and that process is going on, my lord.
All right. As jointly prayed for, re-notify 4 weeks. Give a date. You just don't write 4 weeks. Count the date and tell us. Sorry.
Obliged, my lord.
Obliged.
28. Oh, 28.
May I mention item number 22, Lordship?
Item number
22, Lordship.
22. Yes.
I beg 2 days time, Lordship, to file affidavit in this matter.
It's a PIL matter.
Yes,
What
Yes,
is this about?
it is your lordship regarding the non-construction of the 3 number of roads as per the specification, and also it was a time-bound project.
No, that's right. But one particular road,
3 roads.
3 roads.
Yes.
And you have the grievance against the government, or you have the grievance against the contractor?
Government as well as the contractor, your lordship.
You want
50% completed.
50% is completed.
They are supposed to file this as a status.
All right. What time do you want?
Lord, I need 2 days.
2 days.
2 days.
As prayed for, I have agreed to
On
by the Land Council.
Your lordship, I will be away this week, your lordship. I am
So
going
therefore, you tell us, asked you.
next week, any day.
As prayed for next week, Monday.
Monday. 28, 7.
Right.
28, 7.
May I please your lordship? So item number 10, lordship.
Item number
10, lordship.
10. Aren't you late?
Lordship, I
Huh?
only a day after tomorrow, lordship. I have some difficulty, lordship.
That's right. Normally, I am not very reluctant to grant adjournments, but don't make it a practice.
No.
Today, tomorrow, all right?
Okay. Lordship, actually, I was not in.
As prayed for, 2 days.
23rd. Any other request?
May it your lordship. My lord, it's a prayer for listing a matter tomorrow, my lord.
What is the urgency?
Urgency is that, my lord, today and tomorrow, interviews are going on, my lord. I have been disqualified, my lord.
Interview for what?
For the post of fishery development officer.
For the post of teacher in
Fishery development officer. Fishery.
fisheries. And why have you been shut out?
My lord, I have been shut up, but I was working on contractual basis for last 7 years. During my tenure
No, tell us. It is against against an advertisement.
Yes, madam.
And what does the terms of the advertisement say?
My terms of the agreement says there, madam, the maximum age limit is 38 years. But I am at present 42 years. They have not considered my past service. I was working in there, madam, in the department for last 7 years.
Was that an indice which was to be taken into account?
Yes, madam.
How do you
the-
say that?
The
Can
rule
you
says so.
show that part of the advertisement which says that
Sir, yes,
so
madam.
much of concession
Yes,
will be
madam.
given to you?
No, madam. There is no weightage. But the rule says,
Forget about weightage.
madam. But let that matter come to war, madam.
Therefore, unless you satisfy the court
Madam.
about the urgency, we might not.
Madam.
If it comes in usual cause, we will see.
Madam.
But if you don't make out a case, why do we fix it at the top?
Madam.
No, you're affirming what I'm saying.
Yes, madam.
That way we are rejecting your prayer.
Madam, since there is a service rule, the rule says that any of the clause of the rule can be relaxed. But that,
So that discretion is with the authority.
yes, madam. That's dictionary authority,
Yes.
but the
Have you pleaded that someone else
Madam.
similarly situated has been given that privilege?
no, madam,
Then what case do you have?
has come forward. But no one had the grievance.
Then sir,
But
what case
I
do you
was
have?
working there,
Let it come in the usual course. We'll
but
see.
then it will become influx of madam.
No, it will not. The hands of the clock can be turned back.
Let me try my luck tomorrow, madam.
All right, tomorrow.
Always, always. Leave the person.
All right. Tomorrow.
Daily list for this item 1.
Yes,
May I please, Lordship?
yes.
My lord, it is a contempt petition, my lord. Here, my lord, the judgment at page 8, my lord.
One test. Yes,
My lord, judgment at page 8 to 26, my lord, relevant portion at page 26, my lord.
yes.
Respondent is directed to make payment of arrear salary to the petitioner
So what
within 3 months.
It's a content matter.
My lord,
It's a content matter. What is the reply? Reply has been.
no reply, and the last occasion they said that they going to file review petition after 2 years. And within 1 year after filing this petition, I have taken steps 3 times. All the times that they received the notices, but willfully they avoid to appear before this court. Subsequently, they appeared when
Yes,
I have
wait.
filed.
Yes, my lord. I'm representing the respondent number 1, my lord. In fact, we have filed a review, my lord.
You're merely saying that you have filed a review would not cut much ice.
That I understand, my lord.
You have to give the review number.
It's a filing number, my lord. In fact, in the last order, it has been recorded, my lord. Order dated 24/6/2025.
And not only the number, we will have to be satisfied that you have taken all steps to expedite the hearing of the review. It's something relating to payment of arrears.
Yes.
You don't dispute that he deserves it.
Yes, my lord.
Do you? Do you dispute it?
There are some
Review on what grounds?
review on, my lord. His initial appointment was in a fencers stage, my lord, in a high school. Thereafter, my lord, that school was provincialized in the year 1991. After that, my lord, he joined in another school, my lord.
Listed.
I don't know, sir, they've not asked for prayer for listing.
When would the review be listed?
My lord,
See, this concerns payment of money which is due to the petitioner. Right?
yes, my lord.
So you can't take it so lightly.
Yes, my lord.
Be rest assured, you're only saying that you have filed a review would not help you out.
In fact, my lord, the only difficult,
Tell us when do you expect the review to be decided?
my lord, give me a 10 days.
I believe the practice of the courts is that the review petitions are dealt with on priority. Is that the practice here?
Yes.
My lord,
So tell us when it is listed. I give you 1 week time.
my lord, give me 10 days time. I will take the steps.
All right,
to-
2 weeks. A contempt petition has been filed for the proposed contemners not having complied with the order passed by this court. the Land Council for the state submits that a review petition has been filed. However, the statement does not, this statement is not qualified by giving the number of the review petition or the expected time when the review petition would be listed and disposed of. In any view of the matter, on the insistence of the Land Council for the respondent, the matter is adjourned for 10 days to be listed in priority on so and so date.
6-8.
Obliged. Obliged, Lordship.
Item number 2.
May I please, Lord?
Yes.
Lordship, in this case, Lordship, respondent number 1 appeared and respondent number 2, Lordship, in spite of receiving notice, Lordship, he is not appearing. And Lordship, in this case, Lordship, the respondent
Who's the respondent number 2?
is the Director of Secondary Education, Lordship.
And what is this case about?
A case regarding Lordship, petitioner's provincialization of service was revived by the judgment, Lordship, writ appeal number, Lordship, 185/2024.
What happened? Provincialized.
Provincialization of service.
The order of provincialization
Yes,
means regularization.
Yes, Lordship.
Yes, then what happened?
Lordship, till date, Lordship, authority has not allowed Lordship to work in the school, Lordship.
You're not working now.
Lordship,
You're not working now. Provincialization would have the sequitur of you getting benefits. Right.
Lordship, provincialization earlier allowed, but because of an interim order, his Lordship, this provincialization order was withdrawn. Later on, Lordship, after interference of this court, Lordship, that withdrawal was interfered and his provincialization service was revived.
Right. Then,
That Lordship, they have not allowed Lordship. He's
Why?
going to school, but he's not allowed to sign the attendance
yes,
register.
state.
My lord, I'm representing the respondent number 1. My lord. I have filed my ballot number.
Hmm.
I am praying for some times.
You're appearing for which respondent?
Respondent number 1, my lord. The secretary to the government
And
office.
respondent number 2?
2 is the director of secondary.
secondary.
Yes, has he been served?
Lordship, yes, Lordship will find in the office note dated 5
No, but the director of education would come under the government, and if the state has received notice, I think you can.
No, personally.
It's a contempt.
It's a contempt, my lord. Normally we
Contempt, Lordship.
file ballot number in respect of contempt number.
Land Council, on behalf of respondent number 1, has appeared and has sought some time to put in his response to the petition. Despite respondent number 2 having been served, he has chosen not to appear. Let a court reminder be sent to him for appearing the matter on the next date. Re-notify. We give 2 weeks.
Yes, my lord.
Obliged, Lordship.
6-8. Item 3.
May please, His Honor.
Yes.
It's a contempt matter for non-compliance of the judgment and order dated 11/12/2024.
Page of the order.
My lords, would find the order at page, starts from page 12, my lords, the relevant portion, page 61, paragraph 42.
Page 61.
61, para 42.
That is a SLP.
Here the contemners are served, my lords, and
Paragraph, which paragraph? did you-
42, my lords.
What is it? Read it out.
I'll read, my lord. Just give me a moment, my lord. The APAC is directed to declare the results of the appellants within a period of 2 weeks from the date of production of certified copy of the judgment and order and forward the same to the state within 1 week from the date of declaration of the results. The state government is directed that on receiving the recommendation from the APAC as directed above, it shall provide appointment to the appellants on the posts reserved as per direction of this court and as per their merit within a period of 4 weeks from the date of receipt of the recommendation. Now, insofar as the APAC is concerned, my lords, they have already come.
We're
But
worried
I'm-
about something else.
Lordship, I'm,
The single judge rejected the petition, rejected the
Right,
prayer.
right, madam.
The division bench allowed it.
Exactly, my lord.
But the fact remains that you have not passed your preliminary examination. Is that correct?
Lordship.
No, my lords, I would not put it that way, my lords.
You say yes or no.
No, my lords, because what was the challenge? My lords, I'll just briefly narrate the facts, my lords. My lords, these petitioners who are students, my lords, they had appeared for the APAC 2018, the combined competitive examination, my lords. There was admittedly, my lords,
the answer key for the preliminary examination was flawed. That's an admitted fact, my lords. There were some discrepancies in the answer key, and we were disqualified by, my lords, a very few marks, my lords, because of the faulty answer keys, my lords. Thereafter, we approached this Honorable High Court and we challenged the answer key. But unfortunately, my lords, that challenge was never entertained by the Honorable Single Judge.
That is, the problem lies there. There is the fault line.
Right.
Now,
Exactly.
you were permitted to appear in the mains examination.
Right.
You should have made efforts to have that case decided in which interim order was passed.
No, it was that case only, my lords. In that case,
That's right.
Right.
But interim order was, I mean, that was never confirmed, no?
it was confirmed. Interim order was never confirmed. What had happened, my lords?
The
After-
case was never decided finally.
Yes. So what happened? I'll just very briefly, my lords, point out, my lords. After appearing,
We are on a different issue altogether.
yes,
You say that, but
Yes.
what does the division bench say?
my lords, division bench, my lords,
Paragraph 42, you've said.
42,
is a
42 is
positive
the
order. It's-
relevant,
it's a
my lords.
matter.
And in fact,
It's a
after
contempt matter, no?
the judgment, my lords, the
No, if
APSC
you have
is
filed
of,
SLP,
yes,
Yes, my lord.
number of SLP,
But today we have filed the affidavit. I have given a copy, my lord. It is not on record. I have given the copy.
my lords,
Paragraph 3 of the affidavit may kindly be seen.
Mhm.
Paragraph 3, page 69, my lord.
judgment
may-
was rendered in the month of December, my lord. They have filed an SLP in the month of May, my lord, 25, and it's still defective, my lord. I've just checked the
No,
case
defect
records.
is, defect
just
is,
give us a minute.
lodge.
Defective.
It's only the diary number.
Yes,
Diary number I have given, my lord. And
Now,
they-
we are not, here we are not questioning the correctness of the judgment passed by the division bench.
my lord, that-
Unless you have it modified,
Absolutely, my lord. My lord, what I would like to submit, my lord, some defects were there, those are rectified. The petitioner's hearing, they are on caveat, they have been served. But I'm told, I'm informed that it is going to be listed shortly. I pray for 2 weeks' time, my lord, under these facts, my lord.
normally we wait for
yes, my
the.
lord. Otherwise, my lords, I wouldn't have objected, my lords. But the timeline, after 6 months, they have preferred an
The
SLP,
Supreme Court will decide
my lords. My lords.
whether to entertain the petition or not.
It's still defective, my lord. My lord may instruct my learned friend to get it listed as soon as possible.
My,
Have it listed.
I'll,
Otherwise, there's a very clear order.
that's.
Exactly, my lord.
That's true.
You need to comply with it.
Lord.
My lord may fix it after 2 weeks, my lord. In the meantime, let them
We
try
have
it.
some reservations about the correctness of the division bench judgment, but then nonetheless, it's the contempt jurisdiction. We'll only look at that.
That's,
Yes, ma'am.
All right.
that's true.
So as prayed for on behalf of the respondent state, re-notify 2 weeks. As a they strike it out, just write it. A civil servant, a civil service aspirant did not pass the preliminary examination, leading to questioning of the correctness of the key answers. A learned single judge of this court permitted the writ petitioner to appear in the mains examination. Fortunately or unfortunately, the petitioner passed the mains examination. But the writ petition in which an interim order was passed permitting the petitioner to appear in the mains examination was never concluded. Thus, as on date, the petitioner has passed the mains examination but has not cleared the preliminary examination.
Viva was as well, my lords, after the means.
A division bench of this court, after going through the entire ticket of facts, allowed the prayer of the petitioner and held that the petitioner was entitled to be appointed, to be appointed, for which necessary directions were made. Now, this order is under challenge by way of SLP before the Supreme Court. The SLP is lying defective in the registry of the Supreme Court. And the land counsel for the respondent has informed this court that perhaps the SLP shall be listed in a short while from now. Perhaps this SLP will be listed within a short time. 2 weeks time, therefore, has been prayed by the respondent for informing this court about the outcome of the SLP. We notify third week.
I'm deeply obliged, man. Right.
7-8. Item 4.
What is this case?
May I please allow. Here is the case, my lord.
Which order do you want to be state?
That your lordship will see the annexure at page, my lord. Last annexure, 287.
Yes,
Page 287 is the order which I will put on.
287.
My lord.
I don't think 287.
No 287. For lordship is taking IA, sorry, sir. Sorry, my lord. Extremely sorry. That your lordship will see the impin order which we put
1 second, 1 second.
at page 12, my lord.
Gentlemen.
He was not a part of this, he was not a party. Where they challenge his non-selection, non-provincialization of this system. So the court has directed this authority to look into the petition, it is potentially while considering another case. Other case that he doesn't have. Because of actually your provincialized, another person has challenged it for the he has not made a party. I'm not exactly telling only his body, but I should be made a party. In 4041.
Let's see the judgment. Where is that part? The direction. Where is the direction? You had referred to some page of the judgment.
My lord, that is the impugn judgment, my lord. That's what I.
Where do we find it?
Lordship in the, in IA lordship will see page 12. Operative part starts from page 13, my lord.
Flagging me at here. IA, where is IA? You flag it properly, no? Where is the IA?
Oh, no, where is?
Thanks for flagging.
Start from page 12, my lord.
Yeah, it starts from page 12.
Question. May I ask a question?
Yeah, please, go ahead.
That 4041 of 2019 is the first writ petition, correct? I'm not the party. You're not the party. That is where the trouble started. Yes. And by, where is that? Where is that? Yes, my lordship kindly turn to memo of appeal. Memo of appeal? Yes. It's from 100. Judgment to corner. Huh? Page 60. 68, na? Page 60, money. Nice market. Oh, sir. Page 60 of memo of appeal. You have to start from page 60 of this.
Is 16.
Operative part lordship will see para 9. Just release the different. And para 12. So this lady in the appendix, there was that working in a school. So three of them were provincialized, this, including the present defendant. This transitive Bora page 16, he was not provincialized. So he filed the petition.
And that has been held to be not maintainable.
No, and then, no, then it said that, this single judge said that the authorities should look into whether the petition therein could be provincialized.
That's right. Then
And so he was provincialized, the petition, and in the process, the provincialization of the appellant was withdrawn.
why is it?
And it's not, appellant was not a party, then what happened was, so he can, the appellant had challenged
That's right.
that,
So
and now the,
what is this presentation per se that needs to be answered?
that's one, and another thing is that, since there was, yeah, and there was another thing, now we have made an application for challenging that this page 60, this page 60 also, since he was not a party there. And there is a,
Let this IEB respondent short time.
yes, yes.
So who appears for the other side?
Other side, my lord, that's the caveator. I have served them copy, my lord.
I am for the respond
All,
number
my lord,
7.
both the
in
private
appeal number
respondent had appeared.
176,
You're the answering respondent.
my lord. And
This requires to be answered.
my lord.
When would you put your response? 3 weeks is a long time, no? Keep it 2 weeks normally. 2 weeks.
My lord, I'll pray for the stay, my lord, because my job has been snatched away. Before coming to that, lordship, kindly have a look
2
at
weeks
page
is not going
8,
to-
my lord. I agree upon your lordship. Before that, my lordship, kindly have a look at page 8, my lord. I have given datas. A managing committee appointed me first. Lordship, kindly.
That's on the merits of the case, no? We will deal with it. See, your case and the other, the case of the other person. the Bora, that should not have been mixed up. Nonetheless, they need to
Lord, they
respond.
made a prayer, my lord. Because of the impending order, my lord, I have been asked to prefer a claim. That's why.
We don't think that it's a case for stay now. We'll see what happens.
Lordship, absolute.
Yeah.
Huh?
Respond number 1 and 10.
Well, I am for the respond number 7. In the repeal number
Let counsel
176.
for the response.
Oh,
number
yes.
7 and 10.
It is also there.
Submit that the petition for stay shall be responded by the next date. Re-notify 2 weeks.
In other case, there is a leave also there.
There's a delay of how many days?
A delay of my lord, 1303 days.
1305 days.
Oh, let consolidated, let consolidated notices be issued in the stay matter as also in the limitation petition.
Only my lord, leave has to be granted, my lord, then
Just a
lordship will
minute.
examine.
And in the stay petition. The notice is accepted by respond number 1, respond number 7 and respond number 10. Who have assured this court that they shall respond by the next date, 2 weeks.
8th of August.
Lordship, in this manner, April 176, I am for the respond number 9, madam. Sorry, madam. It was
7 hata ke 9
okay.
Obviously.
Item number 5.
May I please, your lord?
It's this, 14.
Delay of 14 days.
Lord.
Okay. IA number so and so has been moved by the learned counsel for the petitioner, seeking condonation of delay of 14 days in preferring the petition. For the reasons stated in the application, the delay is condoned, the application stands allowed. List this matter under the appropriate heading on. We keep it next week, then you argue on merits.
Obliged.
38.
14 days, we don't issue notice.
Yes.
Item 7 and 8.
Yeah, please, Lordship. This is an appeal under section 35 of Central Excise Act by the Department of. Against the order passed by the learned CSET. Lordship, the fact of the case is that the SAC filed an application for fixing a special rate, combined application was filed.
But on the notification lordship, to determine their special rate, they have to file separate application. Initially, their appeal was dismissed. Against that, they preferred appeal that was allowed. Holding that, citing one judgment, that it is covered, but lordship, the facts of that case is different. Lordship, I've submitted 3 questions of law
Yes.
for consideration of a lordship. In separate state laws.
Is section 35G repealed?
No, lordship, it was again lordship revived by the Supreme Court judgment in Salem Bar Association case. Earlier it was repealed.
But what methodology for adding, for giving special rate?
Lordship, under notification 33 of 2019, there is a provision for filing a special application.
Notice,
Lots.
No, but give me the act center.
notice to the respondent on steps being taken by the, this is the appeal. On steps to be, what is it?
Appeal, sir.
Notice to respondents on steps taken by the appellant within a period of 2 weeks, both modes, returnable on, give a date after 6 weeks.
Much of it.
Twenty-seven, 8. Item number 9.
Both in 7 and 8 both. Yes.
Is the retail selling this judgment on order dated 1/5/25 plus page 109 whereby dismiss the writ petition The main plea of the petitioner is that to grant a pension The petitioner serving is the initially transport department and subsequently absorbed in the corporation, Assam State Transport Corporation, and thereafter retired in the year 2002, But only see page 80, filed impugned letter, the prayer of the petitioner rejected, stating that the petitioner has not completed 5-year service in the year on 13/3/1970. The petitioner serving 9 years, 9
Let's see
months.
the order of the learned single judge. Let us see
109,
the order, let's see.
109.
109.
109.
Relevant portion 122, page 24.
Order 24.
And page 29, observation, of the learned single judge, 125, page number.
Have you placed on record the notification of 31/3/1970?
It's reflected in the order itself, my lord.
What is it?
It pays 121.
But also, kindly see
Read
page
it out.
93, page
Sir.
93.
Just a minute. Read it out.
Sir, may I read, my lord?
Yes.
It's a notification of 31st of March 1970.
Yes.
Exercise of the powers conferred by subsection 1 of the section 34 of the Road Transport Corporation Act 1950. Central Act so and so. The government of Assam, after consultation with the Assam State Road Transport Corporation, hereby gives the following direction to the state corporation relating to the recruitment, conditions of service, and wages to be paid to the employees who have been transferred to the corporation, namely, number 1, all permanent staff of the State Transport Department, Assam, and such of the temporary staff as had completed 5 years of continuous service in the State Transport Department, Assam, on or before 30th of March 1970, are deputed to the corporation on foreign service, the terms and conditions of which are laid down in FRN SRs. They shall be entitled to the benefit of their previous service under the government for the purpose of leave, pension, pay, seniority, and other service
Therefore,
benefits.
5 years service is a must
Yes, my lord.
in the parent state department.
Lordship.
And then only the public sector, government public sector would give pension.
Pension.
Otherwise not.
Yes, my lord. And they have not.
This is notification. Is it in teeth of the statutory rule?
No, my lord. No, my lord.
Yes, it appears to be so. Assam Service Pension Rules,
Pension rules.
1969. Let's
My
see.
lord.
Where is that?
Section 98, my lord.
Where do we get it?
Rule 98, my lord.
निकाल के Which rule?
Rule 98, my lord.
Oh, this is something else.
Yes,
Mr.
my lord.
Counsel. This is something else. This is the governor's discretion
My lord.
to allow a government servant in superior service proportionate pension. That's something else.
Yes, my lord.
Now, if what you've pleaded
My lord.
and what ground you've raised, that would be of no consequence unless you challenge the very circular.
Yes.
My lord.
And you say that it is in the teeth of the statutory rules that you have not done.
As per my lord, Rule 98, my lord, subsequently.
98 is absolutely different. It doesn't concern, it doesn't affect you.
Permanently absorbed, permanently under the.
There are
what you call, my lord.
certain facts which are not disputed. You did not complete 5 years in the state service. Where do we find fault with the judgment of the London single judge? Well, Mr. Counsel, you can try your luck some other time. Today being the first day here, we will not dismiss your petition. This can be disposed of today, but then we'll do it on
Notice may
some
be
other
issued, my
day.
lord. Notice may be issued, my
This concession is only for today.
lord. My lord. Notice may
Lord,
be
we
issued.
can fix the matter next week, my lord. Next week.
What?
Lord,
Keeping, let's take his convenience date
Lord.
as prayed for on behalf of the felon.
I'm so deeply obliged.
Don't raise such issues, no? And if you raise, you must plead it. Now, suppose it were so. Suppose the statutory rules said that no, nothing of this kind, no minimum period.
No.
And then there is a circular. You could first challenge the circular as being in opposition to or in contravention of the statutory rules. Without doing that, even if it were so, you would not have allowed your petition. Right? There was a judge sitting in the division bench against the judgment of a single judge. He doesn't sit in exactly like in appeal. We have to, you have to show that the order is perverse, absolutely bad, beyond rules, per incurium. If two views are possible in appeal, I think the order of the London single judge is not to be interfered with. We do interfere, but then for that you have to make out a case. All right. Now, don't take it as decided. You can come out with new arguments on the next date. Today, I have asked my brother that I will not be dismissing any petition today. So next.
Deeply obliged, Lord.
Next week, yes, sir. Next week. 28/7,
2 weeks. Now.
after 2 weeks. 4/8. Item 11.
Okay.
So he was, so he was removed from service before departmental proceedings.
No,
Put it in a criminal case. That's what. He moved to.
Yes, sir.
My lord, on the last occasion, your lordship was pleased to issue notice.
No.
My lord, your
Today is
lordship,
the first occasion.
my lord, it had come last on 19/6/2025, my lord. My lord, I'm just praying for 2 weeks' time. Can you be any date after 2 weeks, my lord? Just accommodation for today, my lord.
Your acquittal in a criminal case is of no consequence to us so far as dismissal is concerned. You know the law.
No, I'm. The only thing is, my lord, it was held to be beyond, the charges were held to be beyond reasonable doubt in the DP, which is absolutely, my lord, per se contrary to the findings of the learned court below. That is my only point, my lord. I'll try to satisfy your
It's
lordship.
a very slender ground, a very small aperture that you have. Let's see.
I'll try.
As prayed for on behalf of the appellant and petitioner. As prayed for on behalf of the petitioner, I notify 3 minutes.
Oblige.
Item 12.
Ishad Ali Lane.
Second time this comes.
No, that's right. But it says that no action was taken on the 130. No, we will be issuing notice on a different issue. Now, this would hardly be a public interest litigation, even though it concerns a public road, which is under encroachment. Every encroachment is not a public interest. You would be having a statutory rule for eviction and for removal of encroachment. Everywhere there is a rule, there is a statutory rule for removal of encroachment. Authorities are earmarked. You file an application before the concerned authority. No question of 133. 133 is public nuisance. Correct? Public nuisance is when there is no dispute about nobody being the owner of the land on which there has been an erection of hut or hutment. That's a different issue altogether. The issue is that whether the encroacher claims the land to be his, he cannot. Therefore, these facts have to be rested in a proper proceeding, not under Article 226, even if by way of public interest litigation. We understand it's not a vested interest litigation. You are a public spirited person, but then there is a danger of, you being dubbed as an interloper. Suppose there was an order passed by this court for you to agitate before the correct forum under 133. What happened then?
That, first of all, whether.
No, first answer my question. Don't go by what,
Yes, yes,
go by your impression, answer the
yes,
question.
I have hesitated before the district magistrate by your filing the representation, then demarcation was conducted. to
One
ascer-
thirty-three, where is the question of district
No,
magistrate?
no, 133, it is 33, section 33 of CRPC, Lord.
133, yes,
Uh,
133. Not 33, CRPC then. Removal of public nuisance, what happened?
Then representation was filed in accordance.
Where is the question of representation, sir?
This the liberty was granted by this honorable court and in accordance. with-
Liberty to approach, liberty to invoke the jurisdiction of the court. Come to 133. The authority is executive magistrate. Why do you bring in district magistrate here? District magistrate is not the authority. Suppose you file an application under 133 before this court, what we will do?
Lordship, this representation was presented before the district magistrate. That is true.
Sir,
But
you're
it
not
was-
understanding what the court is telling you.
Lordship,
We don't want to repeat. We
yes,
don't want to be harsh. This is a simple issue. You had come before this court earlier.
Lordship,
The court had asked you to go before the appropriate authority for 133 proceeding.
Lordship.
Who is the appropriate authority under 133? See the code and then tell us.
Magistrate, Lordship,
Ah.
executive magistrate.
So therefore, what representation before district judge, if district magistrate? Where have you filed that petition and you have come again for inaction? For inaction also, you have a forum.
Lordship, my simple understanding, I may be wrong. I may be allowed to submit one thing.
Where you may or may, the court may be wrong,
Yes.
but you have to satisfy the court, no? Prima facie, we find
Yes,
that
yes,
you have chosen the wrong forum.
Lordship,
You are
I'm,
barking up the wrong tree.
Lordship, I'm not disputing whatever Lordship is suggesting
No,
me.
please,
I'm
you have
absolutely
every
agree.
right as a lawyer to dispute.
No, these are the technical aspect. That is why this 133 where to submit. So wrongly I have submitted, that I admit. That I admit,
What is your name, Mr. Counsel?
abject Mojumdar. Abject
Mr.
Mojumdar.
Mazumdar,
Lordship, one more submission, that I'm on the spirit of my PIL, that it is confined by the authority land court staff, that there is some encroachment of the land of the public road. This is established. But yes, Lordship is correct that I have wrongly submitted to the district magistrate. It has to be suggested before the executive magistrate. That is true.
why, even that is not the correct forum. If there is a rule for removal of encroachment, you have to first go there. That is very similar and in fact akin to the provision under 133, but 133, it has to be proved that it's a nuisance. Suppose the encroacher says that, no, this is my land. The allegation that the road has been encroached is incorrect. It has been considered to be a road because of easement, because of continuous usage as a pathway. But that does not take away the right of the person who would claim, who could claim that he has his land and over which construction has been made. So these are issues which can't be dealt with in public interest. As a general, you can't just file petition like this.
No one is, Lordship, I am
Sir,
not,
I would advise you,
yes, Lord.
the better way out is to withdraw this public interest litigation and to approach the authorities for the needful. The appropriate authority would be, you have to tell us, I don't know, I've come today. You must be having a rule for removing encroachment.
Lordship,
There is that public grievance something.
No, not even that, brother. The estate from where I come from, that's known for, encroachment on public lands. And we have a rule called Bihar Public Encroachment Removal Act. Right, so you must be having something like that.
yes.
Where is that? You tell us.
Today-
How do we
today-
interfere in this public interest
Lordship,
litigation?
just day after tomorrow, it may be listed. I'll enlighten the court about the rule.
So to cut short the matter, you can, I'm not dismissing any petition today, but you can withdraw this in order to go before follow the directions of the learned single judge who had given you the liberty.
No, that was passed in the PIL also. Just liberty was granted to the PIL.
You'd have done better by withdrawing this petition. Nonetheless, we give you time today, otherwise we would have dismissed it straight away. And if repeated, then cost of 500.
I'll withdraw and Lordship liberty may be granted to approach the proper authority.
After some arguments, Mr. Mazumdar, learned advocate, seeks permission to withdraw this PIL to enable him to approach the appropriate authority, invoking the jurisdiction under section 133 of the Code of Criminal Procedure. It appears that the petitioner had earlier approached this court by way of public interest litigation, seeking removal of encroachment on a particular road, the mid portion of which was alleged to have been encroached. Mistakenly, the petitioner made a representation before the district magistrate bearing no result. The petitioner has come again before this court under PIL, seeking a direction to the concerned authorities to do the needful, as also with a grievance that there is complete inaction on the part of the authorities in removing the encroachment. As noted above, for the petitioner having chosen a wrong forum for initiating a proceeding under section 133, we accede to the request of Mr. Majumdar for withdrawal of this case, for filing a fresh petition before the appropriate authority under section 133 of the Code of Criminal Procedure, 1970. Dismissed as withdrawn with the liberty aforesaid.
Item 13.
Where is Mr. Majumdar? Just a minute. I had promised that I will not dismiss, so disposed of as withdrawn.
May I please as your lordship?
Mother died in 2006.
Yes. Which item has been called?
Item 13.
30. Yes.
May I please as your lordship?
Yes.
Lord, the matter relates to my lord compassionate appointment, my lord. Lord, the learned single judge, though it had been dismissed for my lord non-appearance of the council, my lord, but he has gone into the merit. And my lord,
No, that's all right. But
Fine.
on merits.
merit
Plus
now.
on merit. So if a petition is dismissed for non-appearance,
My lord.
you file LPA.
No, my lord.
You file writ appeal.
No, my lord, it has been decided on merit,
Merits.
that's why.
Oh.
That's why. my lord.
Let's see, where is
The
the,
merit
where
has
is the
been-
order?
is at page 13, my lord, annexure 1.
Page 13.
1-3, my lord. Lord, on basically on.
Just a minute, give us a minute.
Fine.
The petitioner is 4 years old at the time of death.
Wow. When did you, and we are very sorry, I mean, you were in distress, but when did you come of age to apply?
Yes, my lord, it is after my lord died in the year.
No.
My lord.
You were 4 years old when your mother died.
Yes, my lord.
Now, therefore, you became eligible for being appointed in which year?
2022, my lord.
2022.
18 plus 4.
Compassionate appointment after how many years?
2006, my lord.
After 16 years.
My lord. My lord, as I have attained the majority of late, my lord. The
Period is over. You have been able to tide over somehow the other.
My-
Bravado.
my lord can
But then can we look into it?
my lord can appreciate as a compassion, my lord. Because, my lord, once a father died, my lord, the family is always in distress, my lord.
That's a backdoor appointment which is prohibited. You have read the latest law, the
That is
judgment
correct.
rendered by Justice Dipankar Datta. 28 grounds have been raised wherein any interference could be made for compassionate appointment.
My lord.
I don't remember the name of the case, but the principles are very
My
clear.
lord.
Those are only reiteration of the old principles. We are sorry to say this, but this is no compassion. This would be a judicial overreach. If we interfere in a matter like this, where you come to the court, where your eligibility arises after 16 years of the death in harness. I don't think you have a case, sir. क्या करेंगे? Because dismiss the command.
My lord, we relied.
Withdraw this petition, but what benefit would you get by withdrawal?
My lord.
This is one case which cannot even be adjourned. It is a burden on the registry.
My lord, one judgment by the Honorable Apex Court, my lord.
Judgment. We are aware of all judgments on the last of the judgments. You must see. We can adjourn it only for the day for you to see that judgment by Honorable Justice Dipankar Datta, and otherwise, which is recapitulation of the entire principles developed over a period of years.
My lord, delay is very fatal, my lord, for the company.
Fatal.
My lord.
The right gets extinguished. You have been able to survive.
Lord,
This is only for providing succor to the family in distress. Yeah, you were in distress, but you were taken care of. You survived 16 years. You have come of age to apply for job.
my lord.
You can't make death the ground for entering into government service through backdoor. That would be unfair to others who want to come in through competition.
Look.
Anyway, you don't have a case, sir. There is nothing to argue. We will discuss it tomorrow.
Day after, my lord.
Huh?
Day after, my lord.
Day after.
My lord.
As prayed,
My lord. Sign.
as prayed for on behalf of the petitioner. Day after tomorrow.
Oblige.
I'm repenting that I made a promise in the beginning that I will not dismiss any.
Oblige, sir. Highly oblige.
Item 14.
Yes, sir.
The loan was taken by the respondent number 6.
May please, your lordship.
From the respondent number 5 by mortgaging the land of the petition.
And who's responsible? Just give us 1 minute.
This is the individual private. I don't know why it is before the division.
Lawful owner of the land. Respondent number 6. Respondent number 6. After Malik. And who is he? Zainab is उसी के परिवार के. He's the son of the petitioner. Son of the petitioner.
Petition.
You'll have to fight it out in civil courts, not in this writ petition.
My lord,
The son has sold the property, no?
my
Son
lord,
has mortgaged the property.
my lord,
So the-
that is a,
Just a minute, the description of the property is no different.
my lord, that land is a different land.
That's not your case.
Son has mortgaged his own land.
That's not it. That's not. your-
Son has mortgaged his own land.
have you said that?
Let his land may be taken. Why my residential
right.
house may be attached? my
That's
lord?
right. That cannot be done. But where is the statement in your petition
Yes, my
that
lord.
the land which is mortgaged by your son? Your starting paragraph appears to be different.
My lord.
Read paragraph 3 of your petition. Paragraph 3 of your petition.
Yes, my lord. Son of the petitioner without knowledge of the petitioner. My lord,
So why by knowledge? If
My-
the son has a
my
different
lord-
track. Therefore, we did not proceed further.
my lord, I being mother, he
No,
has
but-
not never informed me. That is my grievance, my lord. That is my grievance,
This is the, you're saying something else now.
my lord.
You said that you have a separate tract of land, your son has.
Yes, my
different-
lord. I have,
Where have you said?
I have, my lord,
Where have you said so? Therefore, I said in the beginning that this is an issue which you have to rest out, which you have
my
to
lord,
agitate.
my lord,
Civil
kindly
code.
have a look at the paragraph, paragraph 3, my lord. He has allegedly obtained a loan from so and so from by now, giving mortgage another plot of land situated land dark number so and so. Sutiapara, Moza, Sanga, PS, adjacent to the land, closely adjacent to the land described under Zomundi Bite Annexation number 1.
And therefore, if.
My lord, my
Gentlemen-
land is close to that land, madam.
It can't be. Then without knowledge ka kya matlab hai? Why do you say that it is without knowledge? It is adjacent, the property is fluid, I mean, the boundary is fluid, he must have, where is the loan document?
My lord, the annexer 4, my
Why
lord,
do
the
we even
possession.
issue- Why do we even issue notice to
My
the
lord,
bank?
possession notice, my lord, annexer at page 21, that describe the mortgage property, my lord.
And that's not your property.
Not my property, my
Yes,
lord.
bank,
I'm not against
what
that,
do you
my
have to say? You're for the bank.
Yes, your lordship.
What do you have to say?
Your lordship, they have taken the home loan.
So,
At the time of taking of the loan.
we are asking you a different question.
Yes, your lordship.
The claim of the petitioner is that even though her son has mortgaged his land for taking home loan, that land is different from the land which is over which a construction was made and you have possessed it.
And that the constructions was made from our loan and we have verified the property.
Construction was made from your loan, but
Yes,
then the land belongs to her. No? That was never mortgaged, no?
Your lordship, then the survey report will be required only for that. If the
Yeah.
land is different.
The
Your lordship, that erupts only after issuance of the surface symbolic possession.
we are issuing notice, we are not staying the operation, we'll see. You appear for ICICI Bank.
Yes, your lordship, 4 and 5.
And this possession notice is pursuant to Surface Act.
Yes, your lordship. They
We are not
get it verified from the DRT.
No, you tell us, that's all right. We know the law,
Yes, your lordship.
Surface,
Yes, your lordship.
not to interfere lightly. But then you have to tell us,
Yes, sir.
you can't possession. The same land, the construction was, that must have been made by her consent. Why did you allow it? Look at this. Now we perceive in a different way, Mr. Counsel, try and understand.
Nice.
Now your son mortgaged one portion of the land. Of the
Different land, my lord,
different land.
my lord,
We're taking that situation.
my lord.
Obtained loan went bad. But your son chose to construct his house
No, my
out
lord,
of the loan.
absolutely wrong, my lord. My land is pre-existing, my house is pre-existing, my lord. And that is not correct, my lord.
We should notice, you have to clarify.
Yes, sir. I will bring all.
Clarify. What's your name, Mr. Khan?
A.R. Sikdar.
Mr. Sikdar, learned advocate for the petitioner, submits that her son, that the son of the advocate for the petitioner submits that the son of the petitioner, who is the respondent number 6 herein, had taken home loan from respondent ICICI Bank by pledging a land belonging to him. The petitioner, bracket mother, owns another land, but contiguous to the land which was pledged, on which there exists a pre-constructed structure. The loan taken by respondent number 6 went bad and surface proceedings were initiated. Pursuant to such proceedings, the notional possession of the house constructed out of the loan, out of the home loan. What have I said? Home loan has been taken by the bank. Mr. Sikdar insists that for no apparent good reason, the land of the writ petitioner, the house of the writ petitioner has been possessed by the bank. The land counsel for the bank submits that the survey report and the details of the land would demonstrate that the contention raised on behalf of the writ petitioner is factually incorrect. Accepting notice on the bank, the learned, what's the name?
M. Sharma, Mukesh Sharma.
Mr. Sharma, advocate, submits that he shall be responding to the petition by the next date. 2 weeks.
Your Lordship.
All right.
My lord.
Your Lordship, they have not bring out a title deed of their property.
You respond then.
My lord, there's maybe some
I'll do.
interim protection restraining them to proceed further. Right?
We can't do that. You know, SARFACI law is very strict. We need to have it on fact. If
My-
what you're saying is correct
Yes, my
and
lord.
they can't demonstrate it, we'll state
If,
immediately.
if the
Yes, sir.
saying is not correct, I will withdraw my ukalatnama, my lord.
6-8.
Wait for 2 weeks. I have not
My
given
lord.
a long time.
Item 15 and 16.
Item number 15, my lord, we have already filed our affidavit, my lord. 16 is identical, my lord. That affidavit will cover 15.
That's
same. I have already served a copy of the affidavit to the council for item number 16.
I received it yesterday evening, your lordship, so I may be granted 2 weeks' time. And it may be recorded, your lordship, because on the last occasion, a specific submission.
My
was made.
colleague made a wrong statement that he will file
Allow
separate.
him to complete, no? Allow him to complete.
Yes.
Midway you start talking, no?
Pardon.
Yes.
Because lordship, there are two PILs, PIL 62 and PIL 66. In 66, they have already filed an affidavit in opposition.
He said.
Yes, and in PIL 62, on the last occasion, they had stated that a specific affidavit will be submitted in PIL 62. But they are now,
The issue is safe.
same.
He will say that he says he will rely on that affidavit only.
that may be.
Contesting this case.
Yes, your lordship.
That we have said.
I am on.
Now, what do you want to say thereafter?
Lordship, I seek 2 weeks' time to
You-
file my reply. Your Lord.
What is the issue?
Lordship, the issue here is the de-reservation of a wildlife sanctuary without your lordship obtaining the approval of the National Board of Wildlife under section 26A of the Wildlife Protection Act.
And what have they objected to? What is their response? You have not seen.
Lordship, they
You
have
have not seen the affidavit.
Lordship, I have just received yesterday evening, but I have seen it.
What is it, Mister?
My lord, we had issued a preliminary notification declaring our intention to convert a reserve forest to a wildlife sanctuary. But thereafter, my lord, when we proceed, my lord, we found faced with certain difficulties. Like, my lord, there are several villages of tribal people, my lord, who are protected under Forest Rights Act. So it was found that it will be very difficult for us to convert that reserve forest to a wildlife sanctuary. So those, my lord, facts we have narrated, but the forest will remain forest, it's a reserve forest. We intended to convert it to a wildlife sanctuary, which very,
You're not laying any railway track there.
no,
You're not allowing any mining operations.
no, absolutely not, my lord.
Lordship, another aspect
No.
is that it is,
This is important, no?
yes,
This
yes.
is important. This is an answer. This is an answer to your poser. Now you need to respond. You need to go through it.
I will go through it, your lordship. And one more aspect, there is also a standing order of the Honorable Apex Court in Center for Environmental Law and WWF as next.
That's right.
There, without leave of the Honorable Apex Court, they cannot de-reserve a wildlife sanctuary.
We have not.
And recently, in another matter, your lordship, another sanctuary.
You heard his reply. no?
Yes, I will
You
respond.
heard his reply, no?
I will
Though
respond.
you may not have gone through the affidavit, but you heard.
I have
what he
gone,
said.
I have gone through it partially, your lordship. I will respond to the affidavit. I will grant
I mean,
2 weeks.
what is your name?
V. Raj Khoa, your lordship. V. Raj Khoa.
V. Raj Khoa.
Khoa, Raj Khoa.
Mr. V. Raj Khoa, learned advocate. For the petitioner submits that he has been served with a copy of the response affidavit only yesterday. He wishes to go through the same before addressing the court. For the aforesaid purpose, he seeks a short adjournment. Re-notified 2 weeks.
2 weeks' time. Lordship, one more aspect, your lordship. In the cause list, your lordship, my PIL was registered prior to PIL 66 Mine is shown as serial number 16.
Does this matter?
Subsequent. Lordship, I'm just highlighting.
Does this matter?
My lord, in item number 15, I appear, my lord. In this case, my lord, response of the railways will be necessary because
Let's see.
I have,
If there is, I mean, if there is no railway line,
yes, because
crossing
they have
through-
floated a tender.
let's see
Yes.
on that day.
4th of August. Item 19.
On behalf of the state lords, we have received the instructions yesterday evening. I am praying for 3 or 4 days time to file the application.
What's
In
your
fact,
name?
one of his main grievances has already been sorted out.
Aviation. It's like, you will also put a you know.
You are the Advocate General, Assam.
Lordship. There is a challenge to the rules.
Oh. No, challenge to the rules. Let's see which rules have been challenged.
This is Assam Secondary Education Provincialized School Service Rule 2018, my lord. In
And
this
they have challenged it on what ground?
ground, my lord, actually there are policy of the government to amalgamate the upper primary schools with the high schools, my lord.
Okay, they want that amendment. They want that, where has it?
Yeah, we have amended on
Again,
21st of.
Mr. Advocate, the learned Advocate General submits that the instructions in the matter have already been received and a response to the petition shall be filed shortly. The prayer of the writ petitioner is to direct for carrying out necessary amendments in the Assam Secondary Education bracket Provincialized Schools bracket close Service Rules 2018. Ensuring that graduate teachers from amalgamated upper primary schools are also included for being considered for promotion and other service benefits.
Lordship. Basically for principal's post.
Promotion to post of headmaster.
For
Headmaster.
promotion to the post of headmaster.
But another repeat.
Let this, just a minute, let this matter, let us, I mean, I don't interject, no, so let me complete the order and then use. Let this matter come up for consideration again. We put it after 3 weeks.
Yes.
For me, I'll take 4 days, next week.
4
Lordship.
days. So we say 2 weeks.
2 weeks.
Give an affidavit in advance to him.
Lordship, I'll do that.
And if you have to rejoin, you can do that within that period. Let the affidavit on behalf of the state be filed by 2 weeks. With a copy in advance, with a copy served in advance to the land council for the petitioner. For him to rejoin if deemed necessary on or before that date. List on 3rd week.
11/8.
My lord, another similar requisition pending, my lord, WBC number 2617/2025.
It's not on the list here.
It is not on this, it will tag there.
Let it be, and that matter would come before DB1 only.
Yes.
And let this petition be listed along with, give the number.
WBC 2617/2025. Obliged.
Highly obliged, Lordship.
Item 20.
Nobody appears.
Mr. M.K. Chaudhary, yeah. Mr.
No, these.
Item 20, okay, 20.
20.
Nobody appears on behalf of the petitioner.
Mr. D. Upamanyam.
You are
For the state lordship, higher education department.
the land council for the state is, land council for the state, however, is present. List this matter again for consideration on your date next Monday.
Next one. Highly obliged.
7. 28/7. Item 21.
Meeting the lorships. Because this petition, appeal my lord, released to consideration for provincialization of a my lord teacher in ME school. What happened, my lord?
In 1987, the.
Give us 1 minute,
My lord.
just 1 minute. Challenging. Rejection was also challenged. Shows that part of the order, the learned single judge, where you were non-suited on the ground that you have not challenged the rejection of your claim.
Oh, my lord, which
Well,
is wrong, which is wrong.
Which is wrong. So show that.
Your lordship will kindly come to, my lord, paragraph 15. Paragraph, my lord, 13.
You'll
at page
have to
100
give me the page number.
Page 110. The last sentence, it starts the last sentence, paragraph 13. May I read it, my lord?
Yes.
As noted above, this court in the writ petition being number 898 of 2014 has observed that in view of the enactment of the new Act of Assam Education, Provincialization of Services, Teachers and Reorganization of Educational Institutions Act 2017, the respondent authority may consider the case of the petitioner under section 13(6) of the said Act 2017. I am of the view that the respondent authority, particularly the Director of Elementary Education, Government of Assam, appears to have considered the case of the petition.
See this, we
My
want to see that part of the order which says that you had not challenged the decision.
My lord,
You had only challenged the process by which your case was dismissed.
paragraph 14, my lord. Then.
If that be so, that's a good ground for entertaining this appeal. Otherwise, we'll ask you to argue. So where is that paragraph?
Okay, paragraph 14, my lord. It is true that as per section 13(6) of the Assam Education Provincialization Act 2017, for consideration for provincialization of the school, the services of the employees are to be placed before the District Scrutiny Committee DSC. However, since the consideration appears to have been made in its proper perspective, merely not placing the case of the petitioner before the District Scrutiny Committee.
And shows from the memo of the writ petition that you challenged it.
Petitioner has not.
That's right, we have seen that.
Oh, my lord.
We read the paragraph in advance, no? So just one fault line has to be seen.
Yes.
Now show us from your petition.
Yes, my
that
lord.
you have not treated it.
Your lordship will kindly come to page 72. That is the prayer, my lord, made in the writ petition.
Page 72.
72, my lord.
Yes.
Read in the nature of certiorari or any other writ or other direction like nature towards setting aside and causing the impugn order bearing number 9/8/2022, Annex D, that is under challenge, man.
And which ground have you taken?
There's no reason for page 43.
In the pleadings also, my lord, in paragraph, in page 66, we have specifically stated about, my lord, challenge to that order.
Yes, who appears?
Yes, Lordship. Lordship, here I have received an exception only yesterday, Lordship. I need to file my affidavit counter, Lordship.
But the affidavit should contain the answer to this question. Now, one of the grounds which weighed with the learned single judge was that he was the learned single judge, that the writ petitioner, the appellant here, had not challenged the rejection. He had only challenged the process. That it was not sent to not sent for scrutiny as mandated under the rules. That appears to be incorrect factually. All right. What's your name?
SMT system.
Louder,
It's SMT system.
SMT.
Chisti. Mr. Chisti, learned counsel for, learned advocate for the state.
For education department.
Respond number?
1, 2, 3, and 4.
Hmm?
All, my lord.
1, 2, no, 1, 2, 3, and 4 lordships.
Mr. Chisti, learned advocate for response number 1 to 4. Submits that he has received instructions in the matter and shall be filing his response to the petition shortly. Let that be done by the next stage, 2 weeks. Don't, in your affidavit, don't beat about the bush. You talk
Yeah.
about this.
Yeah.
huh? Just mark the grounds and then answer it.
All right.
Item 23 for final disposal.
That, this we will do tomorrow, day after tomorrow, next week. Place it next week, not today. And this one, we put it in the next week, next Monday.
A date, I have a date to be fixed in this case.
Or you yourself want a date?
Yes,
Okay.
Your Honor, because there are more 4
That's right.
writ appeals
Yes,
along with.
Otherwise also, we were taking a date.
Okay.
Four other items are connected to this matter.
So maybe-
Same issue will say along.
Those will, I mean, those issues shall be decided according to this. So let it be heard. And then next day we will have all the appeals listed and we'll say as has been directed there.
Yeah.
Do you have a state of Assam or, I mean, the state policy for litigation here? No. You don't have a policy for litigation. Anyway, we'll find out what is to be done. All right. Thank you very much. It was a pleasure seeing you all.
Thank you so much.